when I was first trained in collaborative law, I was dying to do collaborative law. So I kept looking for the perfect couple to take into collaborative law. Well, I couldn't find a perfect couple, or if I found somebody I thought would be perfect, then the other lawyer didn't want to do collaborative. So then I said to myself, okay, what I'm going to do is I'm going to practice and tell every client who comes through the door about collaborative law. Just to practice, whether or not it makes sense after I hear the information about their case, I'm just going to do it. So every client who came in the door, I told the whole spiel about here's how it works and this is what it is, just so I could practice explaining it. Well, a woman came to me who came to me because there was a protective order hearing in a couple of weeks. Her husband had her picked up on a mental health warrant, taken for observation while she was being observed, and she didn't need to be in the funny farm. He filed for divorce, asked for custody, and asked for a protective order to keep her away from him and the children. So she came to me and she wanted me to represent her. And there was a protective order hearing in 2 weeks. Well, of course, I told her about collaborative law because I was practicing. And when I was through, she said, gee, I think we could do that. And it was everything I could do not to tell her she was out of her mind. But I said, really? You think you and your husband could do that? And then I looked at the papers she'd been filed, and lo and behold, the attorney on the other side was one of the people who went with me to the initial training in Dallas, and I knew that she wanted to do collaborative law. So I said, well, I'll call his attorney, and I did. And I said, you know, you're not going to believe this, but you know that protective order hearing, well, your client's wife has come to see me, and she thinks they can do collaborative law. Well, when she stopped laughing, she said, okay, I'll call my client. But, you know, I don't think this is a collaborative case. Well, she called her client, and he said, oh, yeah, that sounds really good. And so now we've got both of them sold on collaborative law, and we've got a case where a husband has gotten his wife picked. I mean, it was just, to me, not a collaborative case. But what the heck, we're stuck now. Our first collaborative case. I'm excited, I guess. Anyway, it's one of the best collaborative cases I ever had. Basically, they were rules followers. You told them, you know, you should talk nice to each other and be polite and make I statements and follow this process. And whatever we told them to do, they did. And it was like one of the easiest cases I've ever had. And we did it, we brought in a financial person to work with us on things that we were doing. We actually did our first attorney referral model case. Anyway, when that was over, and I looked back at it and I thought, the clients will self-select, okay? You give them the options, and not just collaborative law. I think we have an ethical responsibility to tell a client every possible way their case can be resolved. They can resolve it at the kitchen table. They can go to early intervention mediation. They can do it collaboratively, and they can do it in litigation. And each one of these has advantages and disadvantages. And we, I think, have an ethical obligation to say to them, it's your life. These are the different things and the different approaches. What do you think will work best in your case? I think now people who don't tell clients about collaborative law may get sued someday when a client finds out that they weren't told about it and their neighbor was, and their neighbor had a very successful collaborative case. So I tell every client who comes in about every possible outcome, including litigation. I tell them I no longer do litigation. I can give them names of good litigators. But at any rate, I think clients will self-select in most cases. Then the job is persuading their spouse to do collaborative if that's what they want to do, and I arm them with articles from newspapers and brochures and websites they can visit and so on, and then I cross my fingers. The only cases I think that are inappropriate are substance abuse, where there's active substance abuse. It's very difficult, I think impossible in a litigation case, to deal with someone who is on crack cocaine. They won't tell you the truth. Their priorities are to get a fix. Their priorities are not to get through a process. I can't work in litigation or anyway with active drug abuse. If they're willing to go into treatment, to go to rehab, to stay clean, I can work with them. There are some forms of mental health diseases that make it very, very, very difficult. And so I would have to be sure that there was a mental health person, professional on the team who really understood the issues, whether it's bipolar or OCD or whatever. I would want to have that there. There is a dispute in the collaborative community about domestic violence and whether or not you should be doing collaborative if there is domestic violence. And I've spoken to people who are active in the DV community. I know from experience as a litigator that it is a disaster for a domestic violence victim to be in litigation. You put them on the stand, and on cross-examination they fall apart, and it appears to the court that they've been lying. They can be confused. It is very, very hard to win a case in custody sometimes for a domestic violence victim. You'd think it would be a piece of cake, but it's not. And so you look at the disadvantage they have in litigation, and so the questions you have to ask yourself: am I competent to help this person? Is it going to be safe for them to be doing it? Can we create a safe haven for them to come to? Can we put up some sort of security rules? Do we have the assistance of a mental health professional? Absolutely crucial. It's scary. Now, I know attorneys who won't touch it with a 10-foot pole, and I also know of attorneys who routinely bring domestic violence cases into collaborative law. I'm not sure if it was a very high level of violence, whether I would be comfortable doing it, but that's personal to me. I don't know if my level of competence rises to that. But in most cases, most people are sane. Most people want to see themselves as good, and if you give them an opportunity to do that and give them the encouragement to do that, most people, sane people, can come into collaborative law and be successful at it. We attorneys have incredible power. We set a tone. We can have a client come to us and scare the hell out of them. Tell them that they need protection from their spouse. Give them horror stories so that they are, terrified of what can happen and see you as their savior. Or we can tell them, look, if you go into court with the idea of revenge, you may get a good feeling for about an hour or so. But in the long run, what is that going to do to you and your self-image? What is that going to do to your children and their mental health? Let's step back a bit, take a deep breath. We have that power. We can make a difference in people's lives. And the problem is that we never had a way to make that happen. There's always been good attorneys who are cooperative, who work hard, but the system sometimes just screwed it up. You're working along and everybody's being cooperative, and you get a scheduling order from the court. They want to set you for trial in a month. Well, now you better get your discovery out, or your malpractice carrier will be very unhappy. And so suddenly the system is polarizing people. So now we have the skills, now we have the system, and we can make a difference for people.